Hi guys, welcome back to my YouTube channel. Today we'll be answering the question, what happens when the accused retracts or repudiates his or her confession? First, I found it trivial to show the difference between the two terms before making my analysis. Therefore, one must note that the basic difference is that a retracted statement occurs when the accused person admits that he made the statement recorded but now seeks to recant it. This generally occurs on grounds that he had been forced or induced to make the statement, and the statement was not a voluntary one. On the other hand, a repeated statement is one which the accused person avers that he never made in the first instance. The following will be a narration of David Kimani Njoroge versus the Republic, a 1998 case in the Kenya Law Report, and the following is the narration. David Kimani had a girl, and one evening they decided to take a nap. But during that evening, the girl told David that she had something to tell him. What is this thing that made David change his mood all of a sudden? The girl, while she was speaking to David, said that, "I want to leave you because you are a poor man, and my family has also told me." Question that will be made by David to the police, it was revealed that the parents of the girl indeed never wanted him. Now, what will the case turn out to be, and what will the judges say? When David was told by the girl that she had plans to leave him, David also confessed to the police in a statement that he had stabbed the girl 6 times to her death. The girl became property of the state. And the case, David Njuguna versus Republic, begins. David Njuguna was arrested and all the statements were done in the police custody. But David sought for legal advice and was determined to challenge the court of the magistrate, and the matter was taken to the Court of Appeal. Into the brief facts of the case, this was an appeal from a conviction and sentence of the High Court at Nakuru before Justice Rimita. The appeal was heard on 1997 and the judgment was delivered in 1998. The appellant was convicted by the High Court of the murder of his girlfriend as narrated by the story. He was sentenced to death and was appealed against the conviction and sentenced on 5 grounds, in which he says the land trial judge erred in law and facts. He relied on a retrenchment statement to convict the appellant in the absence of corroboration, and that the trial court did not also consider the circumstances under which the cautionary statement was obtained. For example, the duration of time the appellant was in police custody before his statement was recorded. Those form the relevant grounds that I will be discussing on in this documentary. The prosecution relied on 2 sets of evidence to establish the appellant's guilt. These were a confession, a charge, and a caution statement attributed to the appellant, and circumstantial evidence. But where did the confession dispute begin, and how will the people understand this case? The appellant was arrested on 8th June 1992 and the charge and caution statement was recorded by Inspector of Police Abraham Macharia on 18th June 1992. That is a difference of 10 years while the person is still in custody, and the statement delay was one of the grounds that David Macharia had taken this matter before the Court of Appeal. The appellant further objected to the production of that statement at his trial, prompting the land judge to hold a trial within a trial. During the trial within a trial, Inspector Macharia had told the court that he talked to the appellant before recording the statement, and that the appellant was fluent in the English language. This, we stress in this case, Inspector Macharia had said that the appellant was alone and in the office at the time of recording the statement, and the witness added that he did not intimidate, threaten, or promise the appellant anything to make him give the statement. The witness also told the court that after recording the statement, he read it back to the appellant, who signed, and the Inspector Macharia countersigned it. The witness, Inspector Macharia, further told the court, and when he was cross-examined by Mr. Njogona, an advocate for the appellant, that the witness had testified that the appellant neither complained to him nor appeared to have been beaten. Now, the appellant repudiates his confession. Whatever the appellant had said before the police, now he wanted to repudiate it. He said that he never said those words. What are the words that the appellant is seeking to repudiate? The appellant gave sworn evidence during the trial within a trial and said that he did not know anything about the said statement, and that qualifies to be a repudiation. Thus, he refused to accept it. However, the appellant in cross-examination had said the following: I agree the names appearing in the statement are mine. I signed them. I wrote the name myself. The statement was prepared before I signed it. I cannot tell how many statements I made to the police. I did not go to the Inspector Macharia. I did not talk to Inspector Macharia at all. Then, if the appellant did not go or talk to Inspector Macharia, then his claim that Inspector Macharia bet him on 17th June 1992 cannot be true. That was one weakness in his case. When re-examined by his counsel, the appellant had this to say: the following changed the story. I gave a statement about the night I was with the deceased, but I do not know whether it was recorded. I did not agree that I killed, but agree with other parts of the statement. What did the appellant try to mean? Now, this brings us to another paragraph that discusses on the cautionary statement under oath. What is the definition of a cautionary statement under oath? It states that you are not obliged to say anything unless you wish to do so, but anything you say will be taken down in writing and will be given in evidence. These words are known as the caution words. It means that you must be informed that there is no legal obligation on you to say anything or to make a statement. David Njogona, in this case, never stayed silent but went ahead and gave the confession. When Dr. Daniel Oire Gyakie performed a post-mortem examination on the body of Monica, the deceased, he established that there were 12 stab wounds on the chest. In the cautionary statement, the appellant is recorded to have said, I stabbed her 6 times on her chest as she was lying down. The words were used to convict the said appellant. Where an accused person has retracted an alleged confession and he gives sworn evidence in the main trial, that evidence, insofar as it is relevant, may provide corroboration to the retracted confession. And the holding of the court was that we have read through the retracted and repudiated confession, and we are certified and find, after full and careful consideration, that even a most imaginative policeman or anyone else could not narrate the incidents and movements of the appellant to the deceased in such details as are contained in the said statement, unless he was with them or was with either the deceased or the appellant, and the appellant in this case was with the deceased. The court never fell for his imaginative tricks, and the appeal was therefore dismissed. But in dismissing the appeal, the following I discovered they are relevant to this matter. What has the court interpreted previously on relating to retracted confessions? Where did the theme of retracted confession begin from? The courts are almost daily faced with having to deal with statements both retracted and repudiated, and the first reported decision in East Africa relating to retracted confessions appeared to have been made in 1935. I hereby refer to the decision of the court in R vs. Mudurwa 1935 case, in which the court held that it would be unsafe to convict on the retracted confession, and the court in that matter held that the evidentiary value of a retracted confession is very little, and it is a rule of practice, as also a rule of prudence that is not safe to act on a retracted confession of an accused unless it is corroborated in material particulars. At that instance, the matter is still confusing. Let us again look to another case that have explained and modified the later decision. For instance, in the case of R versus Robert Snoyer, a 1939 case in which the authorities were reviewed and the opinion was expressed that the danger of acting upon a retracted confession in the absence of corroboration must depend to some extent upon the matter in which the retraction is made. This meant that in ordinary cases, as a general rule, when a confession is definitely and categorically retracted, it is unsafe for the court to act upon it without corroboration, but after inquiring into all the material points and surrounding circumstances, the court is fully satisfied that the confession cannot be true. There is no reason in law why the court should not act upon it. And now, in a recent case, in 1965, Kamau versus the Republic, the court had the following to say: as we have earlier said, that the other material evidence against the appellant was her own caution statement, which she retracted at the trial. In relation to this, the land judge directed the assessors that it was dangerous to rely upon a retracted confession in the absence of corroboration, but that they might do so if fully satisfied that the confession must be true. He further directed them that they might properly treat the evidence of Wambui as corroboration of the caution statement. That meant that if the person took oath and said that he or she was the person who made the caution statement, that was evidence enough to act as a corroboration. A corroboration is an approval, is a test that defines whether an evidence is eligible before the court. And now, the land judge's direction regarding retracted confession was correct, and that Wambui's evidence, not itself requiring corroboration, was capable of affording corroboration. Now, what is that implication to the cases that will ever occur in the future? Remember, there are guidelines and out-of-court procedures that outlines on how a confession and admission will be taken. There's a separate video that I discuss on the difference between admission and confession in Kenya and the landmark case that went up to the Supreme Court. This is the channel. Click that subscription button.